Good evening to everybody. Welcome to the family law class that I am dealing the gift, and today is the fourth day. Today is the, I believe. So now you read what I posted on the screen so that I could know that you are with me and I am with you.
Good evening to all. Professor Dr. Mohammed Saheb Hussain.
Good, good. And you saw the house.
Sir,
What type of the house it? What type of the roof it is? It is a specific type of the roof is there, and there is a specific name is there for the roof. Do you know it?
no sir.
Then say pass on.
Hassan sir.
Yes, this called gabbled roof. You say this is as a gabbled roof because it is having the like triangles are there. It is like triangles are there. That's why. See here, you could see. Did you see here gabbled roof? Read what is given. Adjustment it.
What are the gabbies on a house? A gabbie is the generally triangle portion of a wall between the edges of intersecting roof pitches. The shape of the gable and how it is detailed depends on the structural system used, which reflects climate, material availability, and aesthetic concerns.
Mostly the gabbled houses are in that area where the snow falls. Because when the snow falls, the gabbled roof, it will slide. The snow will slide it. Suppose if it did not slide it, we can easily make it to slide. Is it or not?
Yes, sir.
Yes, that is the construction they will make it out in the gabbled roof. Yes, and we are at this place, the position, actual and the constructive. This we read it. It should, however, is noted that while the delivery of the position is an essential condition for the validity of the gift. So what is should be delivered? The goods should be delivered, either movable or immobile, or tangible or intangible, or that is actionable crimes. It is not necessary that in every case there should be a physical delivery of possession. Sometimes, no, if a person is living in the same house, there is no question of delivery comes because he is already a possession of the house. So the position of the delivery of which complete the gift may be either actual or constructive. So actual, constructive means implied, already staying over there. Actual, passing on the delivery of the goods to the donee by donor. All that is necessary is that the donor should divest himself completely of all the ownership and dominion over the subject of the gift. Whenever that a person is going to give the gift, he should have to lose all the ownership and dominion over that property. Not a single if, but on condition not should not be there. The relinquishment of the control is necessary to complete the gift. There should not be any control over the subject matter which is going to be delivered as a gift to the donee. The real test of the delivery of the position is to be see whether the donor or the donee reaps the benefit. If the former position is transferred and if the later is transferred, the gift is complete, and if the degree is permitted directly or indirectly to receive the benefit. Constructive position of the subject of gift is therefore insufficient. Therefore sufficient. So now, suppose if you are given the gift, a woman has given the gift to the daughter. Okay, this house is yours, but I stay in that house till I die. Is it a gift?
No
What is the condition?
delivery of position. Delivery
Condition
of
they said is I will stay in the house till my death. That condition should not be there. Once it is given, given it all. Okay, you can stay in the house as a tenant. Is it clear?
Yes, sir.
Yeah, that way you can make it out in that way. Okay, oral gift of an immobile property. In view of the section 123 of the Transfer Property Act, a gift of immobile property which is not registered is bad in law and can't pass the title to the donee. Always, immobile property should be put it in black and white, in writing. Any oral gift of immobile property cannot be made in the view of the provision of the section 123. Mere delivery of the position without the written instrument cannot confer the title under the Muslim law. Suppose you have given the land to him, but there is no written instrument, like a registration is given on his name, then it is not a valid gift. And an oral gift is permissible. They say the oral gift is permissible, but to avoid the further litigation, it should be in black and white. However, in order to constitute a valid gift, the donor should divest himself completely for all the ownership and dominion over the subject of the gift. Yes, you should have to completely given the ownership and the dominion over the subject of gift to the donee. It is also essential to the donee not only to prove that the donor had made an oral gift in his favor, but it is also essential for him to prove that he accepted the said gift and delivery of the position of the gifted property had also been effected. See, not only that he should accept it, the delivery should be given, and truly that he should do declare also that he is going to accept the gift. So although the Hindu law requires the delivery of the positions to complete the gift of the immobile property, the law has been abrogated by the section 123 of the act. See, merely giving the position itself is a good, no doubt it is a possession is how much the ownership? Yes, possession is 99% ownership. Merely passing the position is not enough, but there should be execution of the instrument also be put it in writing and get it registered. This section clearly seems to have the effect of the rendering the unnecessary the delivery of the position, substituting or it does registration of the delivery of position. Both the things are essential. What are the both the things are essential for the immobile property? Yes.
Uh, possession. Possession is important, sir.
Next.
Delivery of subject matter.
Next.
Delivery. Registration, sir.
Registration, both are necessary. Delivering the position of the property to the donee, plus put it in writing, the registration deed. Since the delivery of the position is not necessary, it follows that if a Hindu executes a gift in a percentage of 3 villages by means of the duly registered instrument, but reserve the position of the village in order to enjoy the usufruct during his lifetime, at the same time, provides that he would not alienate the property to anybody else, the gift is perfectly valid. What do you say, usufruct in Arabic terminology? Yes. Usufruct.
Interest, sir. Interest.
I say it is in Arabic terminology. Enjoying the benefit of the harvest.
Enjoying.
Like a mango grew. Enjoying the mangoes. But the tree does not belong to him. Neither land does not belong to him. Ariyat, you should know. Ariyat. Ariyat. So we are enjoying the usufruct during the lifetime, at the same time provides that he would not alienate the property. Yes, you will enjoy the mango. Either you eat it or you sell it. Doesn't matter. Because it is your property. You can throw it in the dustbin also. So, but you cannot alienate the property. That is the land or the mango grove trees. Under the Mohammedan law, the essential of a gift are declaration of the gift by the donor, yes, we already studied, and acceptance of the gift by the donee is the second condition, but both are capable of making a contract, means capacity as well as the sound mind. And delivery of such a position
Not much.
is, yes. Do you want to contribute anything?
అంటే మైనర్ కూడా ఉండద్దు అని అంటున్నారు సార్.
Yeah, the
Sound
capacity,
mind.
I told you, no, capacity means you should be major. Number two, it should be sound mind. So, delivery of the position of such is the subject of the gift susceptible. The rule of the Mohammedan law is unaffected by the provision of the Section 123 Transfer Property Act. Consequently, a registered instrument is not necessary to validate the gift of immobile property. But generally, they say registered instrument is not necessary, but to be safe side, it should be there. Generally, say in the Mohammedan law, a man can keep the 5 wives at a given point of time. But actually, none. Only one is equal to 4. Position means not always actual physical position, but a position which the property is capable of being given. So far as the declaration is concerned, it must be shown that the donor, either in the presence of the witnesses or otherwise, made a public statement that he gifted the property in favor of the donee, that he divested himself of the ownership of the property by delivering the position of the donee. Yes, sometimes in the presence of the many other people, that a donor will give the property to the donee, and he made the declaration also that in the presence of the witnesses that this is the property which I am going to give to the donee. Yes, that is the intention to give the donee, even though there is no registration also there, but still it is a valid gift under the Muslim law. Section 123 of the ATP Act will not be applicable over there. A Mohammedan can make a oral gift of his immobile property subject to these conditions. What are the conditions? Some minor conditions are there. We can see that delivery position being the essential to the validity of the gift. Yes, that is a must. And it follows that there is no delivery position, there is no valid gift. No delivery,
No gift.
no valid
Valid
gift.
gift.
Under the Mohammedan law, a valid gift can be effected with the delivery of position. And if there is a delivery of position, the mere fact that there is also an unregistered deed of the gift, it does not make the gift invalid. That means Mohammedan law say our word is our word is our promise. Is it clear?
Yes, sir.
If I tell once means I told 100 times. That is the meaning of it. Okay, you read this thing from here. Read.
A
A
comparative
comparative.
of gift in the Transfer of Property Act and in Mohammedan law property, gifts as given under the Transfer of Property Act deals only with the gifts of tangible property, and so a release of a security without consideration does not fall under this section.
Enough. So, if there is no consideration, then only it will be a gift. If there is a consideration or the money, then it will be a sale. Though the release of the security may be said to be a gift, still a gift is not one of tangible property. When the certificate of the share is together with a blank transfer from the signed by the registered shareholders is handed over to the buyer by a registered holder, the buyer acquires not all the property and the shares but the title to get the register of the company. Even the shares can be given in the form of a gift. This title to get a register to a choose in an action. Of course, shares we can change the names. Once it is given to you, you can change on your name. And when you want to buy it, when you want to sell it, also when the market rate is high, yes, you can sell it and you will get the profit. So that was the thing. Even that also a type of the gift. Hiba of a corporeal and incorporeal property. What is corporeal and what is incorporeal? Anyone? Either say pass on.
Pass on, sir.
Corporeal, you can touch it. Incorporeal, you cannot touch it. Corporeal punishment, physical punishment. Tangible, intangible. It is not necessary that the hiba must be of some corporeal and intangible property. It may be made only the corporeal property, but also incorporeal property. So any property can be a property under the Muslim law, because there is no distinction of the self-acquired property and ancestral property. The hiba may be made of actionable claims are chosen in action, debts, negotiated instruments, or government promissory notes. Yes, these are all the actionable claims, even those are intangible, incorporeal, but still we can give in the form of a gift. Suppose somebody is due to you, but you can give the right of due to your friend, you can collect the money from him because I am giving such a right. That is called actionable claim. Suppose the mortgage money is there, mortgage is there, you pay the mortgage and I will pay the mortgage and give the thing to the gift. Or something vice versa. Even one can give the gift also. If the mortgage property also he can give the gift, provided he can enjoy the amount, whatever that he is going to get in the mortgage. So a gift of a debt or the gift of a debt to the debtor is lawful both by analogy, qiyas. Analogy means qiyas, that is a source of law, and liberal interpretation, that is called istihsan. A gift takes effect in the two ways. How? By transfer of the right of property, that is called tamlik, or by cancellation or the discharge. isakat. Even discharge also you can make it out. But suppose somebody is having a debt, but you waived it, but it is not amount to a gift, because you are waiving the right. The gift of the debt to the debtor comes under the later category. It is called discharge isakat, iskat, not tamlik. If the creditor releases the principal debtor from the debt, both the debtor and surety be released. The release of the debt may also be made in favor of the heirs of the debtor of this when he dies. You can release in the iskat, you can do it, but actually it is not about the transfer of the property. Existence of the property necessary. In order to constitute a valid gift, there must be an existing property. In other words, the subject matter of the gift must be certain existing immobile or immobile property, like land, goods, actionable claims. It must be transferable under Section 6 of the Transfer Property Act. What are the things can be transferable? It is clearly mentioned in the Section 6 of the Transfer Property Act. In case of a gift of a certain amount, by entries in the books of the account, by credit and debit, and some would be available on the date of gift in the account of the firm whose account are said to be the credited or debited. See, whenever you are going to give the gift, that should be in existence, or the equivalent amount should be existence, so that you can purchase such a gift. Yeah, in the case of the banking companies or other firms and companies who have overdraft facility, even if the sums are not in the credit of the donor or not with the companies or firm, gift may be possible by adjustment of the book entries. Of course, overdraft also people will make it out at the time. The bank will what is encash it, but they do know, they do have the faith that this man is a regular customer and he will definitely deposit. But in the case of the non-banking companies or firms, if these companies or firms don't have the overdraft facility, it is not possible to make a valid gift because they don't encash it. Then it's not a valid gift if there is no facility of the overdraft with the client in that companies, in the banks. The funds are not available. A donation can be made with anything to be in future. That is the future revenue of the property at that instance, but generally what the gift law says, no, whenever you want to give the gift any property, that property should be yes,
Existence. Sir.
existence. That is the wordings. Yeah, existence of the property necessary to in case of hiba. That just now you are written and read also. That is the same thing that he given. But ariyat, see, usufruct is ariyat. Please remember, here it is. Usufruct is ariyat, produce manakfi. The produce enjoy called manakfi. Of course, you could try to remember. If you write such words in the examination, really the examiner feel more happy and he will give the good marks to you. A hiba is an out and out transfer. Some same determinate things are an incorporeal right. It is necessary that such a thing or right must be in existence and can be transferred immediately. Also, in the case of the gift of the usufruct, that is ariyat, where you can the produce only. Ariyat, usufruct, produce, manakfi, refers to the right which accrue from the day to day in future. Such produce or use of the thing becomes a property particle by the particle as it is brought into being. The manakfi, that is called the produce, may thus be transferred by the donor during his lifetime by a gift or by a bequest and be the subject of a gift even though they are not in existence at the time of the gift. Only exceptional cases regarding the ariyat is it is going to come produce manakfi later, but they can give it gift in beginning also. An exception. Equity of redemption can be subject of a valid gift where the property gifted is subject to usufructory mortgage, which is gifted merely the equity of the redemption and not physical possession of the property itself. See, once the usufructory will be enjoyed, that is the ariyat, then a manakfi, that is a produce, he enjoyed it over there, then naturally he should have to return the land as well as the trees to the donor. భక్తుల్లారా నిద్రపోతున్నారు ఇందులో టూ యాక్టర్స్ ఆర్ దేర్ ధోని అండ్ డోనర్ వన్స్ ద యూజుఫ్రాక్ట్ యూ ఎంజాయ్డ్ ఇట్ ఓవర్ దేర్ then redemption will come goes to back to the donor. What is the redemption goes back to the donor? Tree as well as the
Usufruct.
Doni.
Land. Both of them go back to the donor because harvest is over, usufruct is over. Huh? So oral gift of immobile property, this we already did it. We need not to do it again. When gift may be suspended or revoked, yes, this is important. When gift can be suspended or revoked, yes. Now read anyone, yeah.
Section 126 of the Transfer of Property provides for conditions where a gift may be revoked. The following are those conditions: that the donor and donee must have agreed that the gift shall be suspended or revoked on the happening of a specified event. Such event must be one
You
which
are
does
not
not
supposed to
depend
read
upon
in
the
that way.
donor's will.
You are not supposed
Sir?
to read in that way. Number one, the donor and donee must agree that the gift shall be suspended or revoked.
Or
The mutual understanding between them happening of a specified event. Read number two.
number two, such event must be one which does not depend upon the donor's will. Number three, the donor and donee must have agreed to the condition at the time of accepting the gift. And
That's enough. Number two, a particular condition, it is going to happen. A donor is not supposed to know it, which does not depend upon the donor's will. No, it is not the donor's will. Such condition is going to happen. The donors and donee must agree to the condition at the time for the accepting the gift. See, when the donor wants to give a subject matter of the gift to the donee, even donee also in a condition to accept it. Means there is a free will would be there, and both should be a sane mind, and both should be have the capacity. Fourth, the condition should not be illegal. So whatever the condition they put it over there, it should not be illegal or immoral and should not be repugnant to the estate created under the gift. Suppose if there is a agreement between the two that he is giving the land for the irrigation for cultivation of ganja, opium, such is illegal. Only the government licensed people can raise it, and they will sell to the government, or the government land also there to raise such a cultivation, such a thing which is for the medical purposes, medicines, manufacturing purposes. So section 126 is controlled by the section 10. As such clause in gift deed totally prohibiting the alienation is void in view of the provision contained in the section 10. Section 10 also clearly maintains in the Transfer of Property Act, if anything falls under it, it becomes void. A gift which was not based on the fraud, undue influence, misrepresentation, or whether an onerous one, cannot be cancelled unilaterally. So they will not be unilaterally cancelled unless until it is free from the such a coercion. Such a gift deed can be cancelled only by the resorting to the legal remedy in a competent court of law. If any breach is happened over there, if anything is not properly followed over there, at the time one can bring an action in the court of law. A Mohammedan, on the other hand, can revoke a gift even after delivery of possession, except the following cases. Say, a Mohammedan who is generally, you can revoke a gift even after delivery of the possession. If the once the possession is given the property to the donee, still he can revoke it. How? We'll see. Number one, when the gift is made by the husband to his wife, or by his wife to her husband, at the time, can it be revoked or cannot be revoked?
revoked, sir.
A Mohammedan, on the other hand, can revoke the gift even after the delivery of the possession, except means
Can't be revoked, sir.
he
Can't be
cannot
revoked.
revoke. He can revoke, he cannot revoke.
Cannot revoke, sir. Cannot
He
revoke.
cannot revoke because except he said means exclusion clauses. So a gift given by the husband to the wife or wife to the cannot be revoked over there once it is given over there. When the donee is related to the donor within the prohibited degree, yes, when the donee is related to the donor within the prohibited degree would be there, then means brother and sisters and so that cannot be revoked over. When the gift is sadaqah, when once your sadaqah is given, once your charity is given to the beggar 10 rupees, can you ask, no, sorry, I don't have the change. That's why I give the 10 rupees, give me the 5 rupees. Okay, if the beggar is very kind enough, you say, okay, it doesn't matter, I will be happy with the 5 rupees, you take the 5 rupees. Is it clear?
Yes, sir.
When the gift is sadaqah, it cannot be revoked. That's my point. Made to charity for any religious purposes, you should not ask him to give back me because I thought that I do have the money and I give the. Okay, in such a case, you can ask him to get the rest of the money from him. Okay, half you take, half I will take because I don't have the bus ticket price. Okay, four, when the donor is dead, how could he will get it when the donor is dead? Can he ask his son to get the gift? Answer no.
No,
So
sir.
when the thing given has passed out for the donor's possession, suppose you have given the thing, a motorcycle to the donor. That motorcycle, what he did it, he gave to his son, who is studying in the city. Another instance, the property is passed out to the donor's possession to some other person by sale or a gift or otherwise, any way, by sale or a gift by otherwise also. Oh, we even cannot revoke it. When the thing is given is lost or destroyed, yes, suppose it is lost over there or destroyed because of the act of God. At that instance also, we are not going to get it. It means we cannot revoke it. Number seven, when the thing is given as increase the value, whatever be the cause of the increase. So now, suppose he has given a particular land to his father, sorry, the son or daughter. But later on, he came to know that adjacent to the land, there is going to be international airport. That means there is a lot of demand for that land which is near to the international airport. At such a thing, he will say, no, 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 give it back. I will give the more money to you. No, once it is given, because the subject matter of the subject of its value is increased because of the circumstances. Is it clear?
Yes, sir.
Read the eighth one, ninth one.
When the thing given is so changed that it cannot be identified as when wheat is converted into flour by grinding, and ninth point, when the donor has received something in exchange for the gift.
Just now, can you explain the eighth point?
When we
The
give
thing is,
any
the gift,
No,
the
if you
gift
say
is
if you
changed.
say pass on, then you can take the turn.
The gift is changed uh, like that. It cannot be identified, sir. Means the wheat is converted into flour. Like that,
Can
it
you
is.
identify the wheat after converting the flour?
No, sir.
No, sir.
No, because when if the shape is changed over there, then we cannot get it back. So that is the eighth question. The thing is given so changed, he changed from wheat to the flour. It cannot be identified as when a wheat is converted into the flour by grinding. So number nine, when the donor has received something in exchange for the gift. See, already he actually donor should not suppose a donor has received something to exchange for the gift. It is not about a gift actually, because nothing should be exchanged. Only love and affection should be there. So in certain cases, no, one cannot revoke. One cannot revoke. Okay, what is onerous gift? Onerous gift is a gift made subject to certain charges imposed by the donors on the donee. The principle behind this is that he who accepts the benefit of the transaction must be also accept the burden of the same. Suppose a deceased has given all the property to the legal heirs. That means whatever the estate that left by the father, entire thing comes to the son. But whatever the debts left by the father, the entire debts should have to be paid by the son. Because when he's taking the advantage of it, you have to take the disadvantage also. No, 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 no. Debts is my father did it, but I can take the property. They said no. When you want to take the property of your father, pay also the debts of your father. Is it clear? Yes.
Yes, sir.
So that is called onerous gift. This section, being an embodiment of the rule of the equity, applies equal to the Hindus and Mohammedans. For acceptance of an onerous gift, acceptance of the gift itself is sufficient. There need not be any separate and express acceptance of the onerous condition also at the same time. The acceptance of the gift will carry with its acceptance of the onerous condition Also, even though at the time of the gift, the donee was not aware of such a condition, especially where the owner's condition is of a trifling nature. Small amount would be there, only 500 rupees is only 5 rupees monthly maintenance to a certain person's life is there, it can be overlooked. It doesn't, it is not a bigger amount. A donee not competent to contract and accepting the property burdened by any obligation not bound by his acceptance. That means a person who is a donee who is not a competent to accept the gift, then that such a obligation not bound by his acceptance means there is no valid gift. But if after the becoming a competent to contract, then he become a major and being aware of the obligation what we have to do, then he retains the property given, he becomes a bound. See, once he has attained to the majority, but he, instead of relinquishing the property which he got in the form of a gift, but is accepting it means he accepted the gift and continuing it. So that is the whole story behind. Then who is the universal donee? Anyone can read?
Essential condition to constitute a universal donee is that the gift must consist of the donor's whole property. If any portion of the donor's property, no matter whether it is movable or immovable, is excluded from the operation of the gift or the endowment, the donee is not a universal donor. This concept is embodied in Section 128 of the Transfer of Property Act, where a Mahmudian made a gift of the whole of his estate to his son and directed him to pay his debts. The son was a universal donee and he was liable to pay all debts of the donor. There is no rule of Mahmudian law which conflicts with the provisions of this section.
Yes. What did you understand the section 128? Universal donee.
Once he takes assets, he should also be liable to the debts, sir.
That is owner's
Then
gift. That is owner's gift. What about this universal donee? The universal donee is nothing but, see, whenever the property is given by the deceased through the inheritance or by any other means, it has come the gift form, not inheritance, because it is testamentary. It comes to him. Nothing is goes to any other person. The entire property, the donee got it. Not a single pie is left to anybody. And such a donee is called universal donee. The essential condition to constitute a universal donee is that the gift must consist of the donor's whole property. Whose property?
donor's
Property?
property.
Donor's whole property. If any portion of the donor's property, if any small iota of the iota or portion of the debtor's property, no matter whether it is a movable or immobile, doesn't matter, is excluded from the operation of the gift and the endowment, the donee is not a universal donee. అందులోకి వెళ్ళి ఒక్క పెప్పర్ కార్ను కూడా తీసినాం అనుకోండి, a paper car amount of the property is taken from there, then the person who receiving is not a universal donee. The concept is embodied in section 128 of the Transfer of Property Act, where a Mohammedan made a gift of the whole of his estate to his son, whole of his estate, not a single portion, no iota goes to anyone, and directed him to pay his debts. And say, son, I am giving entire property to you. Now, whatever the debts are there for me, you pay and you enjoy the rest of the property. The son was a universal donee and he was liable to pay all the debts of the donor. There is no rule of the Mohammedan law which conflicts with the provision of this section, because there is no such a conflicting section is there in the Mohammedan law. What is stated in the 128 is absolutely true. In conclusion, the conception of the term gift and subject matter of the gift has been an age-old and a traditional issue which has developed into the distinct facet in property law. Different aspects related to gift in a property act and its distinction with the Mohammedan law and its implication has been the major subject matter of this article. So it is just, we can read from here. The concept is important. The concept of hiba and the gift as used in the Transfer of Property Act are different. As we have seen in the subject that under Mohammedan law, to be a valid gift, their essential are required to exist. Number one, declaration of gift by the donor. Number two, an acceptance of the gift expressed or implied on behalf of the donee. Number three, delivery of the position of the subject of a gift. The English law has to write in property is classified with the division on a basis of the movable and mobile are real and personal property. But there is no such a distinction, real, immobile, self-acquired and ancestral. There is no such a distinction we will find in the Muslim law, but we will find only in the English law. And the Transfer of Property Act also. The essential element of the gift are the absence of the consideration, that is a number one, and the donor, number two, the donee, number three, the subject matter, number four, number five, the transfer and the acceptance. The striking difference between the two laws relating to the gift forms and a measure of his project in the underlying and under implication. So thanks for listening, for your patience listening. So this is the thing which I want to share with you of today, and we want to clear that according to our syllabus, it is clearly mentioned revocation of gift, we read it today, and request of valid gift also we did it, gift formalities also we did it, kinds of the gift that we want to cover it. What are the kinds of the gift? So that we have to see it. But still we do have only 9 minutes are there, but let us see that how much we can. Yes, now you tell me, hiba or gift. In gift transfer of property, say hiba as per the Muslim law. In hiba, there is no distinction of the ancestral property and self-acquired property. And hiba, it can be oral or it can be written, either mobile or immobile, doesn't make any difference. But they come to the Gift and Transfer of Property Act, then the subject matter should be in existence, and that we to put it in writing, and that it should be registered. And sadaka means
Charity, sir.
charity. Ariyat means uzufrag. Okay, so now let us see what is the introduction and definition. We know all this introduction and definition. Who is the donor, who is the donee, what is the so and so, what the Transfer of Property Act says about it, what are the Hindita kinds of hiba. Let us see how many kinds of hiba would be there. Just we saw that you onerous gift, and we saw the universal donee. But this terminology, can you read the terminology?
Hiba bil Ivas.
Hiba bil Ivaz. Kinds of hiba bil Ivaz. That means this kind of gift arises when someone receives a gift for an already completed act, which may be deemed as the consideration for the gift. However, it must be certain that deemed consideration was not in a contemplation of a gift. That is called hiba bil Ivaz. That means a kind of gift it is, but how it arises when someone receives the gift. Okay, somebody receives the gift for an already completed act. So some act that he did it, some services he did it for that act, which he may be deemed as the consideration for the gift. So the act consideration is this gift. That you presume that act consideration is the gift. So, however, it must be certain that the deemed consideration was not an contemplation of a gift, but generally that is given as in the token of a love and affection. It is given, not necessarily the that is given. The gift is given in contemplation of the consideration. So that is called hibabil ivaz. For the past services, if anybody gives any gift, that is called hibabil ivaz. The hibaba sharatul ivaz. Okay, let us see what is this. In this form of a gift, a consideration is anticipated, but not immediately. Therefore, it is revocable until consideration is satisfied. Sir, I will give the land to you. Okay, but you have to give me the house. If you don't give me the land, I don't give you the house. So, in exchange, Hibayul Sharatul Ivaz means it is in the form of a gift. Consideration is anticipated. Yes, going to get it, but not immediately. Therefore, it is irrevocable until consideration is satisfied. Unless until you give the land, I don't give the house. The essence upon the satisfaction of the requirement of the consideration. You give the land, I will give the house. And a gift crystallizes to a sale. It is nothing but it is one amount of the sale or one amount of the what is exchange also. Is it clear?
Yes, sir.
Suppose land value is more, house value is less. So what he will do? He will give the house plus some amount to compensate it. So that is called hibabul shartul ibad. Sadaqah, I already told you, this kind of a gift is usually granted to the poor by way of alms giving, which is geared towards the spiritual upliftment. Why you are giving the alms to the poor? Because you will get the moksha. When you get the moksha, you will be put it in the heaven. So that is the belief. Spiritual upliftment would be there of the donor and the performance of the and discharge of the donor's moral obligation. That is called sadaqah. మీకు ఒక జోక్ చెప్పాను చూడండి, 2000 రూపాయల నోటిది తెలుసా? రిపీట్. ఎనీవన్ కెన్ రిపీట్? సార్ మాకు తెలుసు కానీ సార్ వీ కెనాట్ ఎక్స్పెక్ట్. నో, ఐ వాంట్ టు సీ హౌ డూ యూ ఎక్స్ప్రెస్ ఇట్. దట్స్ మై ఇంటెన్షన్. ఎస్, ఈవెన్ దో రాంగ్ డజంట్ మ్యాటర్, ఐ విల్ గివ్ ద ఆన్సర్. ఐ విల్ పుట్ ఇట్ ఇన్ రైట్ వే. ట్రై. ఎనీవన్? I say anyone, or say pass on.
Pass on, sir. Pass on.
One day, a beggar, a person passing by the temple or masjid or church, he has given the 2000 rupees to the beggar. Then beggar saw the 2000 rupees. Then he said, "Gentleman, you have given the 2000 rupees to me in the form of alms to me." He said, "Yes. Once upon a time, I also did the same. Please, take it, give me only 10 rupees or 100 rupees." This joke I told you. I don't know, we can next time when I ask you, are you in a position to give the explanation or not? For giving the explanation, you should be good enough in your vocabulary. You should be, say, in a grammatical manner. That is also an important factor. But this will come automatically. If you go on speaking it, you will know how to frame it because it will be taught to you. We never say, I will come yesterday. Can anybody say? Can anybody say, I will come yesterday? Yes?
No.
Then what do they say?
I'll come tomorrow.
Yes, that is the obvious factor. You need not to go for the any other thing, but we follow it automatically. That is following the grammatical rule. Okay, Aryat usufruct. The form of a gift permits the enjoyment of the property without the inheriting the title of the donor. Because we are not touching the donor title, we are not touching, we are enjoying only the usufruct of the, like a mango grows, we are enjoying the only fruits of the mango. This is a perfect distribution of the licensee relationship. However, there may not be a consideration for the grant of the type of the gift. So usufruct also one of the type of gift, like a license is given over there. You can enjoy the grows when it comes, you can eat it, you can sell it, but you don't have any right to for the sell of the alienate the land as well as the trees. That is called Arya. Okay? Essential, we already dealt it, so we need not to do. Okay. Of course, some of the case law we covered there, and some of the cases here given. And with this, we will want to wind out. And of course, here he has given the difference between the hibabul ivaz, and hibabul sharatul ivaz. In the sharatul ivaz, something should be given back, then only it will be considered. Otherwise, it will not be considered. That we will see it. So, the difference between the hiba and hibabul ivaz, if you want, you can take the screenshot of this one. If not, if you could just scroll it, it will come there. Then you can easily read. When you can pause it, they can read it. Then you can read it, repeat it. When you repeat it, again revise it. When you revise it, you can remember it. Sorry, అన్నీ ఒకటే మాటలు చెప్పారు సార్ మీరు. ఇదంతే ఏం లేదు, చిన్న విషయం అది. Under the hiba and hibabul hartul ivaz, musha is invalid but permissible under the hibabul ivaz. Sorry, musha ఏంటిదంటే we cannot unbreak it. The property is called musha. Suppose the staircase is there, which can be used by both the people, means donor and donee. We cannot break the staircase. Yesterday I told you how many steps I told you yesterday. Staircases, how many type I told you yesterday by showing the picture on the board?
Spiral staircase, rung.
అది రంగు అది ladder ఉంటదండి. Spiral staircase is one kind of it. Another is dog tail staircase.
Tail.
So the rungs are I'm sure that you would have, did you ask anybody, your friend, what is rung? Uh, So hiba is revocable and hiba is irrevocable at the point of the making, and hibabul artha ul livaz is revocable when there is a condition are met. Hiba is a gift all the times and for the intents of the purposes, while the bill livaz is clearly the contract of the sale ab initio. Hiba bas arth ul livaz is the exercise of the position of the crystallized sale. So that is the difference. We will find it in a hiba and hibabul livaz. Then hiba and sadqa is different, because sadqa is charitable purpose when you are getting upliftment of the moksha that you will get it. That's why we will make it a sadqa. And regarding the hiba, it will be given in the love and affection. It can be given to the one person to another person, but both should be competent enough and both should be alive. Is it or not? So this way, if you keep it like this, then you can read also when you are going through my YouTube channel. Is it not?
Yes, sir.
You can pause it, you can read it. Is it not? Like you pause it, then say each one you can read it. Sadqa is all the time geared towards acquainting the spiritual satisfaction and upliftment, which will extend to the afterlife. Hiba is a secular, but it is made out of the affection. Sadqa is obviously irrevocable, but hiba is revocable if the need arises. Sadqa does not require the acceptance, whereas the hiba mandates to express the acceptance. Really, it can be made to the more than person without the stipulating the shares, whereas the hiba is made without stating individual share of the donee. It can be invalid. Means sometimes musha is valid because you cannot break it, like the staircases. So these are the difference that you will find it in the hiba and sadqa. Yes. And I believe that at any time it will stop now. So with this, I would like to end my session, and I will see you tomorrow in the same timings. Unless
Thank you, sir.
I say there is no class, that means presumption is class. Okay. Suppose if you want to say something, sir, because Kunam, this, what is it? Pongal is there, sir, and Bogi is there, sir, Kunam is there, sir, and many other things are there, sir. If you make a demand of it, then I can think it over. Is there any such a demand?
No,
No,
sir.
sir.
Except then presumption is there is a class. So with this, I would like to wind it up. Thank you very much for staying with me. Yes, meeting will end for
Thank
all
you,
the
sir.
participants. Then I'm closing it, and it will be closed also soon. Yeah, leave the meeting and have the meeting for all. And